Oh,
That was the one in Morgan.
yeah, that was so fun.
Yeah.
That was so fun.
And they were behind the ferns.
Yeah, and then Justice Hudson called in.
Yeah.
Yes.
He was like, and then somebody who was over in the place looking at her for
Yeah, and
questions,
asking
and he was like, or something. And that's like,
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Afternoon. Our next case is State versus Calderon, and court would like to thank counsel for their flexibility with our schedule. We'll hear from the appellant.
Mr. Chief Justice, Associate Justices, and may it please the court. I'm Ryan Park from the North Carolina Department of Justice on behalf of the state. I'd like to reserve 5 minutes for rebuttal. This case raises the question of multiplicity. That is, how to determine whether multiple similar criminal acts can be charged as separate and distinct crimes. The evidence at trial here showed that defendant, then a 40-year-old man, aggressively pursued an intimate relationship with a 13-year-old girl that he had met at church, even after being repeatedly informed that she was a child. Defendant corresponded with the child daily on social media, and one day drove to her house in his van when the child's caregiver was away, kissed the child multiple times on the lips and the neck outside of the van, causing bruising on her neck, and then proceeded to spend an extended period of time inside the van. An eyewitness testified 45 minutes, during which he kissed again the girl multiple times, separated by a gap of 6 to 7 minutes. Now, defendant concedes that this course of conduct constitutes at least one count of indecent liberties. The Court of Appeals majority below held that it constitutes two for the conduct outside the van and the conduct inside the van. And Judge Stadding below in dissent would have held that it supports 3 separate convictions. As he explained, the separation of 6 to 7 minutes between the 2 episodes of kissing inside the van, and I'll quote, were distinct in time, permitting defendant to employ his thought process and make a conscious decision to engage in the second act, the same act a second time. The state respectfully submits that Judge Stadding got it right, and we would ask this court to reverse for the reasons stated in his well-reasoned dissent. Now, the particular question of determining how to delineate between separate acts of indecent liberties is a novel question in this court, but in two prior cases, State v. Dew and State v. Rambert, the court has confronted a similar issue in the context of other crimes, assault and discharge of a weapon into a vehicle. Applying the lessons of those cases, the state and our colleagues from the Appellate Defender's Office actually largely agree on the relevant legal standard that we think should apply here, and that's the distinct interruption test from State v. Dew. In that case, this court held that as long as there is some clear break, that's the court's language, between each criminal act, then each act can support a separate conviction for assault in that case, or here, indecent liberties with a child. That break can be an intervening event of some kind that interrupts the flow of the crime. It can be a change in location. It can be a lapse in time, and I'll quote again, that is sufficient to allow a reasonable person to calm down. Or it can be any other event that constitutes a break between an ongoing set of criminal acts. And so if this court agrees with the parties that the Dew case offers a good framework for analyzing the distinct interruption that occurs here, we think it's a pretty straightforward, fact-specific application of that test. And that question would be whether the facts presented at trial, taken in the light most favorable to the verdict, were sufficient to allow a reasonable jury to conclude that there were indeed three separate criminal acts that occurred here.
So you don't think we should adopt the Sellers test?
I think that the Sellers test is largely similar to the test in Dew. The elements are, map on pretty closely. And I think the fact that that test is similar, that if there has to be some separate and distinct act, a lapse in time, an intervening event, a change in location, or a fresh impulse is what the court said in the Kansas Supreme Court said in Sellers. I think that kind of illustrates that common set of common sense factors should be applied in this case as well. I'm happy to speak a little bit about Sellers from this court, sister high court in Kansas. Now, in that case, I think it was a closer case. There was only a 30 to 90 second gap in time between an ongoing act of indecent liberties against a child in that case. So there was a touching that occurred late at night. A dog started barking, and the perpetrator, the defendant, went to go calm down the dog and came back about a minute later. And the Kansas Supreme Court acknowledged that was a close case. Only about a minute in time separated these two acts. But it held that that's sufficient to at least send it to a jury. And I think the logic of that case applies here, which is that if you are interrupted in the course of a crime and you calm down and you go do something else for a minute or 6 minutes or longer, that offers a reasonable person the chance to reassess their conduct. I think we would embrace the assault analogy that I think our colleagues in the Appellate Defender's Office have advanced, that we don't take the position every kiss in an act of indecent liberties is a new crime. But if there's a 6 to 7 minute break or a change in location between a kiss or a set of kisses, then that does constitute an opportunity for a defendant to think, well, what I'm doing is wrong, it's a crime, and it gives them an opportunity to either stop, reassess, and stop committing the crime, or to reoffend again. And that's the logic of Judge Stadding's dissent below that we embrace.
So it sounds like you're saying to me, and in Dew, we gave several examples of the kinds of things that would be an intervening event. But lapse of time is one. But it sounds like you're saying, that lapse of time could be 30 seconds. And if it truly is that short, then why wouldn't a prosecutor be able to charge a crime for every separate kiss? And if it's not that short, how do we know, on just this factor of lapse of time, where do we draw the line? Like, is 2 minutes the correct time period? Is it 10 minutes? Like what's the principled reason for figuring out how long a person has to then decide that they're committing another crime?
Your Honor, I acknowledge that the line drawing problem here, especially if you're only focused on the lapse in time, is a difficult one. And at some point, I completely agree that the distance between two separate acts becomes too close to constitute a separate crime. I think if we were here and there was a 30 to 90-second gap without any sort of other intervening event, it would be a very, very difficult case for the state to prevail on. But I do think that, for example, if I stopped talking for 6 to 7 minutes, I think everyone would agree that that was a distinct interruption in the course of my argument here. And I think that that logic applies to an act of indecent liberties against a child. Now, it's a fact-specific inquiry. I think that the jury should largely have the ability to decide. I think the jury was given the opportunity here to understand the state's evidence, the contrary evidence that the defendant offered, and to decide, well, I think based on the eyewitness testimony of this relatively long break, that the defendant engaged in a separate act of indecent liberties. I do think, if I may, I'd like to talk a little bit about the issue on which the state filed a petition for discretionary review. Now, that is this threshold analytical distinction that the Court of Appeals has adopted in a series of cases and applied here below between touchings and sexual acts. Now, the state would respectfully submit that this distinction has engendered a lot of confusion, even among different panels of the Court of Appeals, that there are a number of cases since this distinction was first advanced in 2006 where the logic of that ruling would make no sense if that distinction were applied. So it's even being inconsistently applied in the Court of Appeals. But more importantly, as Judge Stadding noted in his concurrence, he concurred on this point, the distinction really just has no basis in the statutory text. The word touching or sexual act never appears in the indecent liberties statute. And more broadly, the whole point of the indecent liberties statute, I think everyone agrees, is to serve as a catch-all to encompass a whole range of indecent, improper acts perpetrated against minors that don't fit within a particular definition of a more specific crime, such as rape or sexual abuse. And so it really makes no sense to apply this threshold distinction. Indeed, this court has held in multiple cases that no touching or contact is actually required at all to have an indecent liberties conviction. There are a whole range of factual scenarios that I won't get into here that meet the qualifications, the requirements of the statute, but don't involve contact at all. And so the distinction just really is a confusing one. I think what highlights the error below, we think, is the fact that the Court of Appeals defined sexual act by reference to another statute, the rape and sexual offense statute. And that statute, as this court recognized in Alonzo just a couple of years ago, is really a unique statute because it defines rape in one way, and then it defines all other sexual acts as excluding rape. And so it really just does not make sense to apply to other statutes, and it leads to some pretty odd circumstances, some applications if you were to import that definition of sexual act willy-nilly into other statutes, as the Court of Appeals unfortunately did below. So we would ask just that this court reach this issue and clarify for the Court of Appeals, for the DAs across the state that have to charge and try these cases, that there is no threshold distinction between different kinds of indecent liberties. And instead, we would propose that simply the distinct interruption test from Due should apply to all acts that constitute indecent liberties, and it would be more of a fact-specific application as to whether multiplicity was satisfied in a particular case. So there are a couple other issues that I'd like to address, if I may, and I think one of the large issues that defendant has raised in their briefing is that there was somehow something improper about the way that the indictment was structured or the instructions were structured in this case. And respectfully, I don't think that those arguments are consistent with this court's precedent. This court has repeatedly held in case after case, in cases involving multiple convictions of indecent liberties, in cases involving multiplicity arguments, that there is no requirement that an indictment give specific, detailed factual information about the particular crimes. So in Rambert, which was a multiplicity case, there was a short form indictment, that matched the elements of the crime, and it followed the pattern jury instructions that the Conference of Superior Court Judge issues. And the court said, well, that doesn't mean that there's necessarily some sort of double jeopardy problem here. What we need to do is look at the facts and the evidence that was presented at trial to determine whether there were distinct acts as opposed to the indictment. On the instructions, I don't think this court could have been any clearer. It said in Smith, which was a case involving indecent liberties, and I'll quote, "When instructing on indecent liberties, the judge is under no requirement to specifically identify the acts that constitute the charge." Instead, what this court does in these cases, as in most cases, is it views the facts in the light most favorable to the verdict, and it assesses whether a reasonable jury could have found that there were multiple crimes at issue, as opposed to whether they were specifically instructed on multiplicity, or let alone any sort of requirement that the jury make some sort of factual finding that there was a gap in time or an intervening event. That's not what this court did in Rambert or in Dew. It didn't remand for the jury to make a specific finding. It assessed the evidence itself. Another issue that I'd like the chance to address is the idea that defendant didn't have a knowledge of the basis for the particular charges in the indictment until after he had testified. I think that respectfully doesn't accord with what actually happened below. And I direct the court to transcript page 688. So that was the oral argument over the defendant's motion to dismiss the indictment after the state closed its case on sufficiency of evidence grounds. And the prosecutor in that case specifically outlined the 5 acts that each constituted indecent liberties, and clarified that there was kissing that occurred inside the van, outside the van, and a second episode of kissing that occurred inside the van. And then at the charge conference, after the defendant did testify, even though we would say that this is not required under Smith and Lawrence and other cases, at the state's request, the trial court instructed the jury that on the specific factual underpinnings of each of the indecent liberties charges, and that's at transcript pages 930 to 934, those are the jury instructions that did delineate the specific acts that corresponded to the 5 separate indecent liberties charges, 3 of which the jury convicted on. I think that, I guess the related point is that the defendant has noted, defense counsel has noted, that he did testify that contrary to the eyewitness account, the defendant never testified that there was this 6 to 7 minute gap in time. But that's never how the standard of review works in these cases. In Dew, for example, the defendant testified that no assault took place at all. And he actually testified that there was sort of an accidental assault that took place when he reared his head back. But he never said that there was a second assault that took place in a car. But this court didn't analyze and defer to the defendant's testimony on his different account. What the court did is say, we will look at the facts in the light most favorable to the jury's verdict. And there were 2 separate incidents that occurred, one inside of a trailer and the second inside of a car. And here, the state's evidence was that there were 3 distinct episodes, again, with the second and third episode separated by a 6 to 7 minute break in time. So the final issue, with your indulgence, that I'd like to address, if there are no further questions, is double jeopardy. And the only thing I'd say on that is we completely agree under this court's precedent that the same defendant can't be charged and convicted multiple times for the same conduct. That's the basic gist of the double jeopardy protection in the federal and state constitutions. But that just really collapses the inquiry here. So Rambert is, I think, the most instructive case. Again, that was a double jeopardy case. And the whole inquiry is whether these are separate acts that support separate crimes. And if they're not, If this court holds that they're not, then it does violate the double jeopardy clause for them to be charged as separate crimes. But it's really just the same issue packaged in constitutional garb. And so we think the double jeopardy issue and the multiplicity issue really rise and fall together. So if there are no further questions, I'm happy to reserve the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court, my name is John Corella. I'm Assistant Appellate Defender and a member of the Bar from Durham County, and I represent the appellee and cross-appellant, Mr. Pedro Calderon. This court can resolve every question presented in this appeal by looking to its own established precedents in 3 areas. First, this court's decisions since 1955 have thoroughly explored the intent and meaning of the indecent liberties decisions. Those decisions and the plain language of the law, as the Solicitor General also agrees, establish that indecent liberties is a broad offense that may consist of multiple discrete acts. It's a catch-all. Second, this court has consistently held that statutes with language like the indecent liberties statutes must be construed as allowing only a single prosecution for one continuous transaction, absent a clear legislative intent to the contrary. Every version of the facts in this case supports only a single conviction. Finally, under our double jeopardy case law, the identical indictments and facts presented at trial cannot support multiple punishments without violating the Constitution. I'll begin with the interpretation of North Carolina General Statutes 14.2.1. As Mr. Parks said, the specific question here is a new question, but prior decisions actually provide a lot of guidance on this. Because the other questions that this court has answered over time on the indecent liberties statutes really show how it should be interpreted when it comes to this multiple acts question. The first question that this court had to answer back in State v. Lance in 1955 and Harvard in 1865 was whether indecent liberties repealed other sex crimes. There were defendants who argued that because indecent liberties exists, I can no longer be charged with, say, committing an unnatural act. And this court said, no, this is a distinct statute. It has a broad purpose as a catch-all protection. It's supposed to supplement and not replace these other sex crimes. Second questions that came up is, well, okay, well then is indecent liberties a lesser included offense such that a defendant could argue that if you're charging me with a sex crime, you must, charge the immediate instruction on indecent liberties in every case? And the answer to that was also a no. From State v. Weaver in 1982, and also from the analysis in State v. Etheridge, although that was a sufficiency case, in 1987. This is a different crime. The elements are not the same. This is a crime with different elements, covers a much wider range of acts. And in Etheridge, for example, which was a sufficiency case, although there were also charges of rape and sexual offense in that case, what was charged as indecent liberties, what was described in that indictment, was the additional acts that were done with the child that were not the sex acts. Okay, and that was how this was distinct. The third question, and maybe the one most relevant here, and some of these cases were mentioned during the state's argument, is it's the inverse question that we have today. Can you get one conviction for indecent liberties from multiple acts when maybe the number of acts is not entirely clear, or maybe there are more acts than charges? And this court has held repeatedly you can. And maybe the most helpful case on this is State v. Hartness from from 1990, but there was also the same holding in State v. Lawrence in 2006 and State v. Massey in 2007. And basically, what these held, the challenge in these cases was a unanimous verdict challenge. The idea that if 3 or 4 acts were alleged, but there was just one count of indecent liberties, and the jury wasn't told which act to attach to indecent liberties, could the conviction be upheld? And this court held that it could. And the description in Hart includes saying that, under the facts that indecent liberties was a single offense, and that it also used the words of, the facts described a continuous transaction. So whether any individual juror found this specific incident or another specific incident to constitute indecent liberties, it was clear that the jurors collectively had found that indecent liberties occurred, because indecent liberties is a broad offense that can include multiple acts. All right, and that sort of brings us up toward the inverse question we have today, which is, can the state now turn around and treat indecent liberties almost like it's a granular offense? The statutory interpretation principles that this court applies lead to the same conclusion. And this also gets into the cases dealing with the statutory language about particularly the use of the word any, but there are actually multiple indicators in the indecent liberty statute that this is supposed to be a broad offense where multiple acts can be combined into a single conviction. First of all, the offense is listed in the plural, which is unusual. The definitions of the crime, either A1 or A2, an indecent liberty, a lewd and lascivious act, they are very broad definitions without a lot of specifics about what the act is. And in both cases, a person can be found guilty by committing or attempting to commit any indecent liberty, any lewd and lascivious act. Now, in a number of cases, this court has interpreted that same language to mean that that in those cases, if there's an ambiguity as to whether there are, it would support separate offenses for each incident, or whether the offenses should be a single offense.
So suppose in this case that between the 2 kisses inside the vehicle, that the defendant had gotten out of the vehicle and had walked around for 5 minutes and then had returned to the vehicle and engaged in the second kiss. How would you analyze that?
Well, in that case, I mean, that gets into the sort of due analysis and the multiple transactions there. You need this distinct, you need the distinct separation. Okay.
So it has to be a physical separation then.
Well, there are multiple, it's a totality of the circumstances test. What you don't have in this case that we have in some of the other cases, including the Sellers case, which the state mentions a very short time period, is you have facts showing a sort of disengagement and re-engagement. This is an entirely separate act. In Sellers, there was a thing where they were in the bedroom together, and then the dog barks, and the defendant gets up, goes away, comes back, checks that the mother's still asleep, and then does something else. And they said that's very close. And I'm not saying that Sellers necessarily got that right, but they said that is about as close to the line as you get. We don't have that here. And let me get into the facts, because I think the facts can be a little difficult in this case because of the way the case was prosecuted. It was prosecuted as primarily a B-level sex offense case about the rape charges and the statutory sex offense charges. And that's the way the testimony was elicited. And as a result, the testimony from the victim in this case and from the state really doesn't focus on the kissing. And it actually, the minor, Jocelyn, describes a continuous course of events, but it's a very different continuous course of events. What she describes is essentially, it really would fall well within due. It's kind of a continuous assault where, yes, he kisses her outside the car. And her initial testimony of this, let me just give you the cites for this. So volume 2, pages 197, 198 is when she first gives an account of what happens. Her initial account before the prosecutor sort of starts eliciting some more things is, he grabbed me, he kissed me outside the car, then he pushed me in the car, got on top of me and did a number of things, like pulled up her pants and asked her to do acts. And then it continued up until her grandmother pulled up and she got away. And she actually, in that initial account, doesn't describe any kissing in the car. And then the DA comes back and says, well, did he kiss you in the car? And she says, oh, yes, he kissed me on the neck. And that's it from her in terms of the allegations about kissing, because those weren't the focus of the case primarily. There's a lot of exploration of the other topics. And even on cross-examination, which is for her is volume 2, page 203, there's just the question of, like, did he kiss you all in the van? And she says, yeah, he kissed me on the side of the neck, and just mentions one and not others. She's describing a sort of continuous, a very different sort of continuous event. His description, on the other hand, is that this is not a assault where he grabs her and then commits all these acts, but it is a sort of rendezvous. She's texted him, he comes there, she meets him, they kiss, they snuggle, they get in the car, they hang out, and again it continues until grandma comes back and she tells him to leave. Both of those versions are consistent with a single continuous event.
But then there are the other versions from the eyewitnesses. What I'm trying to understand is, if you take the eyewitness testimony, you've got 2 acts of kissing in the vehicle. They're separated by some degree of time, let's say 5 minutes.
Mm-hmm.
What makes it continuous? I mean, so I gave you the hypothetical that the defendant steps out of the car. Suppose between the kisses he gets a phone call and he takes a call. Is that enough?
Well, I mean, again, it's a totality of circumstance. So it depends on the version of events, right? If you fit that within his version, which seems to be what the jury believed, it would really take a little more of an interruption for this to not be just a continuous session of them hanging out, kissing, snuggling in the car for 10 minutes or whatever it is.
But just sitting there is not indecent liberties, right?
Right. The sitting is not indecent liberties, but there is no break in this transaction. What they are doing, right, is they are together in this car having this, lovey-dovey make-out session kind of situation. All right, I don't know how best to describe it, but there's nothing in there that is where it stops until grandma arrives. There's nothing where he's called away. Now, and I mean, the phone call, I think we just have to know the facts. Right? Is this something where it really is a break? He goes and he does his work call and then he decides to re-engage. But here there's no interruption. And the same is actually true with the eyewitnesses, right? Their testimony is that they see them. And what's interesting is that they testify and he testifies that he could see them too. That this isn't a car with tinted windows. They're in view of each other here. It's not just that they could sort of spy on this, and they both describe, they're the words of the couple, like they're watching a movie together. The woman says, I kept my eye on them the whole time. And then,
the question, though, isn't, were they in the car together the whole time?
Right.
Was there, if we applied the do test, was there a distinct interruption between the taking of indecent liberties? Just sitting there is a break in the indecent liberties, right?
It is not. If you apply the do test, in do, there is an assault that occurs for a period of something like 2 hours in a trailer, followed by the break is the assault stops. He tells the woman to go change the bed sheets, pack the things, we're going to get in the car and go. And then they get in the car, they're going to another place, and then he begins assaulting her again, and that's the break, and that's the separate assault. There's nothing like that. There would be something like that if, there is a break in this case, but there's just no resumption, right? The break happens when grandmother comes. She comes back, and immediately they stop, all right? No matter which version of whether it's her escaping or him being waved away because she doesn't want grandma to see. In either version, like that's the break, right? If something happened after that point, I think it would much more fall within in due. You'd have a period. You could point to a period of time. You could point to a change in location. Someone would have gotten out of the car. It would be a little bit like Sellers getting out. But here, there's nothing like that. I mean, they're describing a section of these two people being together. And if you look at the unanimous verdict cases, they are cases where over a period of time, a number of acts occur, and this court has upheld the ability to make that one count of indecent liberties if a jury finds any of them. The jury doesn't need to agree on a single one because you can aggregate indecent liberties that way. Absent a clear legislative intent to the contrary, and that's what we don't have. There's not a legislative intent in the statute here to charge this as separate crimes for each individual act of touching or whatever indecent liberty act is alleged.
All right, last one. So suppose there is an hour between the two kisses in the car, and they listen to a book on tape. Well, that dates me. They turn on audio or whatever, and Audible, excuse me, and they're listening to a book for an hour, and then the second kiss takes place. Still one thing to
I think that the fact that time passes, I mean, that's what the state elicited from the witnesses, right? It's like time passed, and it weren't there these kisses, they weren't exactly back to back, and then they had to question, like, well, how many minutes, et cetera. Like, well, maybe 6 to 7 minutes between. They weren't describing anything in between. Like, this is what it was. They met up, and they did this. And what's the crime here? I mean, the crime is improperly, like, meeting up with this girl and kissing her and committing this, what they call lewd and lascivious act in the car. And that is all part of one thing. I think that
So just to be clear,
the passage of time, I think to get to your hour question, right? It could be, but I think, again, it would have to be in the totality of the circumstances. I don't think just a set amount of time doesn't need to be and isn't helpfully aligned. And what is here is just sort of the fact that there were 6 to 7 minutes between them in and of itself, it is not enough. But it could be, as in some cases, where even a relatively short period of time, when the facts show that this is a break, that there's a real break. And again, the witnesses did not testify to really what was going on in the car other than we saw them and this is what it was like between them. We saw them kissing and snuggling, and it was like a couple in a movie, and the older sister was sort of saying, like, I kept my eye on them because of this, like that's what they were doing, and then was able to testify to some specific things. The fact that there was more than one kiss in that period, she's not describing separate or different events, and there was a lot of questioning and cross-examination about what they might have seen in that car, because the state was trying to suggest that there were other acts that they might have seen. And the version of events that Jocelyn gave included them moving to different positions in the car, people were moving their pants, other kinds of things. And so there was a lot of questioning, and they really saw them and didn't see that. They just saw two people continuously together, not changing positions, not disengaging, just kind of being together in the car like that. And the kissing was just a part of this. So it, factually, I think makes sense as a single transaction. And in terms of just the statute, this court's like recent cases referring State versus Connolly, which is the one about any gun, State versus Smith, the obscenity case, those statutes that say, as it does in this case, any indecent liberty or any lewd and lascivious act, absent a clear legislative intent to the contrary, that does not create separate offenses for each act. That language has been held to be ambiguous and has been held to create a sort of single continuous offense. And that's the correct result here. Let me talk a little bit about the double jeopardy aspect of this, if I can. There's not a separate indictments issue that we've raised in this case. Okay, the reason the indictments are discussed more in double jeopardy is because double jeopardy analysis begins there. The double jeopardy analysis is an elements-based test from Blockberger. You start by looking at the indictments. That's what the court did in Rambert, and that's what the court did when they cited some of the older cases like Irick that's cited in Rambert for how you look at double jeopardy. And so the first thing to do in considering double jeopardy is you look at what the indictments say. Well, in this case, unlike some of the others, the indictments are identical. There's no difference between them. And this also isn't one of the cases, as some of the sex offenses cases are, where there is a very long date range, right? Some of the indecent liberties cases and others say between 1994 and 2000, some indecent liberties was committed by these acts. These are all charged just in the language of the statute with the same date without differentiation between them at all. So beginning there, on the basis of that, you already, seems like we have a double jeopardy problem. That this person has been charged with exactly the same thing in exactly the same language. And I've cited in the briefs this court's decisions on indictments and notice, and referred to the facts in this case about the lack of notice. And I know the state referred to, right before my client testified, and how there was more discussion at that point after all the testimony was in. This was also an issue at the very beginning of trial. There was a denial of a motion for bill of particulars, and the attorneys, there was a Harbison inquiry done because in opening statements, the attorneys said, Mr. Calderon admits to kissing this girl. He admits to this. And that's going to be the evidence you're going to hear from the very beginning of the case. And at that point, there is nothing. And I think that is, relevant for understanding this issue and thinking about these indictments. But the cases, Rambert included, are clear that you can look beyond the indictments. We allow short form indictments. And so then you do look to the facts, and looking to the facts in this case, it doesn't really get beyond those indictments. I mean, we're looking at a very small, relatively small period of time. These facts are almost all the same. The allegations are almost the same. And the convictions here were not only a problem for sufficiency when we look in the light most favorable to the state, but they're also a constitutional violation under double jeopardy. Another point I want to touch on a little bit is the jury instructions. State mentioned the jury should have the ability to decide. One of the issues raised in this case, which wasn't really fully addressed below because it was resolved on sufficiency, was whether there was an error in the jury instructions here. And I would say in this case, the jury did not have the ability to decide. The jury, unlike in the unanimous verdict cases, was not given a series of acts and asked to find, did indecent liberties occur here? The jury also was not asked to determine if there was an interruption or if these were separate. The jury instructions in this case and the verdicts given to the jury specified each kiss, and if that happened, it was a guilty verdict. There was no decision for the jury. There are situations in which we allow the jury to have this kind of, make this kind of decision. For example, in the jury instruction for kidnapping, the pattern instruction 21025, juries need to make a decision about a separate complete act. That would have been something that could have been done here. Also, as in the other cases, it could have been charged as just a single indecent liberties, and they could have decided which acts constitute the indecent liberties. Instead, the jury was given a series of instructions which compelled 3 independent guilty verdicts for each kiss that was found. And really, there is no limiting principle that's inherent in the state's arguments here. If we go with saying, well, 6 to 7 minutes, and you can think about it again, that was a break, or any amount of time. There's really nothing. If it's just any time passed, that can't be enough. If that is enough, then every kiss, just like every punch in an assault, could be indicted and charged. Okay. The just result in this case would have been that after the jury made its determination to acquit Mr. Calderon of the high-level sex crimes and find only the kissing, is that he should have been released that day. Prior to the trial, he had served, I think it was 735 days in pretrial confinement, more than 24 months, more than the 16 months he would have gotten for one indecent liberties conviction. As soon as that verdict came down, that's what the jury's decision should have meant, because that was why he was being held, was for all of those sex crimes of which he was acquitted. Mr. Calderon has lost the fight for his freedom, no matter how this court rules. Before today's argument, he completed not just the one, but actually all three of the punishments the state set for him. But as the state also agrees, this case has broad implications for judges, juries, prosecutors, and defendants in the future. This court's precedents from State v. Lance in 1955 through State v. Dew in 2021 appropriately cabin prosecutorial discretion and provide guidance for how juries may be charged. Allowing the granular prosecution of each alleged kiss, in this case under the broad language of the Indecent Liberties Statute, would give the state unfettered discretion and draw into question this court's prior precedents on unanimity and on whether it's a lesser included offense. It would also undercut the role of the jury in determining the facts. Pedro Calderon was rightly found not guilty of the sex offenses and kidnapping the state brought to trial, despite having an eyewitness who testified those events never happened. It would be a small measure of justice and a benefit to the jurisprudence of this state to leave Mr. Calderon with a single felony conviction for the one crime he testified to having committed. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. I'd like to make just 3 points on the main multiplicity question and then address double jeopardy and the instructions briefly. So I think we all agree that there are 2 extreme positions that the statute cannot possibly embrace. And one is that no matter how long an interruption in time or how great an intervening event, you can't charge similar acts of indecent liberties in multiple crimes. I think if there were a month-long break, if there were a 3-day break, an hour break, it would not be consistent with the legislature's intent to say you can't charge those as separate crimes. Now, of course, there are easier cases than this one, but that position, I think, can't possibly be the law. I would point also to the statutory text. This was charged under the subsection B, lewd and lascivious act, which is singular. And so each lewd and lascivious act can be charged as a separate crime under the statute. That maps on to the second. This is the second point. That maps on to this court's precedents in Dew and Rambert, which are the multiplicity cases that this court has previously decided. So what this court said in Dew, again, is that a lapse in time that allows a reasonable person to calm down allows for separate crimes to be charged. And so if this court accepts that as the framework to apply here, again, it's a fact-specific application of whether the evidence here was sufficient to show that a 6 to 7 minute gap was a sufficient lapse in time. The same also on the other gap, the other intervening event. The court said that a change in location can constitute a distinct interruption. And it reinforced that holding in Robinson. This was dicta, but in Robinson, another assault case decided just a couple years ago, the majority said, well, if there had been a change in location in the assault from the bathroom to the bedroom, a pretty small change that you don't even have to walk through a closed door potentially, If there had been a change in location from the bathroom to the bedroom, that might have constituted an intervening event. And it said if there had been a lapse in time, it gave an example of an easy case, 3 days. If there had been a 3-day gap in time, then that would have been a distinct interruption. So just in terms of the statutory argument, I think this court's precedent understands, accepts, and ratifies that the legislature never meant to say if you engage in similar acts over a long period of time or where there's great breaks in the location, that can't be charged as separate crimes. And then we just come to, this is my third point, just the facts here. So I'll just reiterate briefly the facts here. There was a change in location from outside to inside the van. And I think it's important to emphasize that was a meaningful change. The defendant himself testified that the reason they went inside the van was to avoid detection. They were engaged in kissing outside the van in full public view, and then they went inside the van because the defense testimony was that the girl did not want her grandmother to see what they were doing. So he went inside the van, and the jury found it wasn't kidnapping, but there's no dispute that they went inside the van to avoid detection. That's a meaningful change. And here, again, there are easier cases than this one. The two excellent Court of Appeals judges found that the 6 to 7 minute gap was not long enough, but we think that Judge Stadden got it right, that if you put yourself in the shoes of a reasonable jury and you think, well, if you pause a criminal act for 6 to 7 minutes, an assault is a good example. If you pause for 6 to 7 minutes and you engage in conversation, even if it's heated conversation, that allows a reasonable person to say, well, if I punch this person again, that is a separate crime. That is re-engaging in the criminal activity and allows a reasonable jury to conclude as much. And on double jeopardy, I would just point out that this court's unanimous decision in Rambert by Justice Frye, I don't have it there, so that the court said specifically that the indictment in that case had identical charges. The words of the indictment on each of the 3 charges for discharging a weapon into a vehicle, an occupied vehicle, were identical. And then it said, well, that doesn't resolve the double jeopardy question. What we have to do is examine the facts. And so our position, again, is simply that the multiplicity question and the double jeopardy question rise and fall together. And finally, on jury instructions, the instructions here were meaningfully more defendant-friendly than in other indecent liberties cases where this court has affirmed multiple convictions. What this court said in Lawrence and in Smith is that the instructions, the indictment, the verdict sheet, all contain generic language that didn't specifically identify the particular acts, and that is perfectly permissible when you're charging these kinds of crimes. And so I don't think a reasonable trial court judge could read those cases. They had a discussion of Smith when this was discussed at trial and think that I needed, under this court's precedence, to specifically delineate the acts that corresponded to the 5 indecent liberties charges. But he did so anyway, at the state's request, to try to bring some clarity to what the charges were that the jury was asked to deliberate over. And finally, I'll just close on this. I agree that the main evidence on the distinct interruption between the 2 acts inside the van were this eyewitness, and that eyewitness was largely exculpatory for the defendant. The eyewitnesses testified, I didn't see the other charged crimes, the more serious sexual crimes, but what I did see is kissing separated by a clear break. And this is on page 413. The witness testifies, I saw them kiss, not back to back, 6 to 7 minutes apart. And then the state's attorney asked, so there was some sort of break in between, and the witness testified, yeah. But I think, given this course of conduct, where the defendant was repeatedly informed that the person that he was trying to initiate a romantic relationship with was a child, that the charges and the convictions here were just as well as the sentence. Thank you, Your Honors.
Thank you, counsel. Mr. Clark.